For today, we will talk about protecting technology. Now, just like in the other lectures or commentaries that I've been doing on specific themes of technology management, I'd like to explore some thoughts and some generic or general ideas regarding this particular theme, which is on protecting technology. And for today, we'll cover pretty much the motivation. We'll talk about what is the object of protection. Okay, we'll talk about the scope of protection, and then we'll talk about the subject, and finally wrap everything up in a hopefully nice conclusion. Now, when we think about protecting technology, we are actually looking at motivation first. I mean, the question is, why do you want to protect technology? Why is there a need to protect technology? Well, there could be many motivations. First is economic, and I think this is the most obvious motivation why you want to protect technology. The reason why you are motivated to protect technology from an economic standpoint is because you want to protect the return of investment or the return of capital that you expect from exploiting the technology. Okay, if you're unable to do that, then in the first place, you might be thinking that I shouldn't have spent money for that because I wasn't even able to extract value from the expenses or from the investment that I've done in actually building and learning the technology. So one motivation can be economic. Another motivation can be political. The reason why you want to protect technology is you want to protect your influence. You want to protect your power. You want to protect your status relative to everybody else. Okay, and that's the reason why, if you think about it, like in the mid 20th century, when we were talking about the space race, like who can actually be the first country to put a man in space, right? If you look at the practical aspects for that, you might be thinking, why would you want to do that? Why would you want to invest time and energy and effort in doing space technology? Just an aside, our own government, the Philippine government, is actually looking into space technology. Not so much as putting people in outer space, but things like developing satellites, okay, and concomitant technology around it. Okay, so that's why there is this field that's being explored by government that is specifically for space technology. But regardless of that, I mean, if you look at the middle of the 20th century, there has been a lot of effort to try to win the race for space. No, and a lot of that is really political in nature as well. It's not because that they will be able to extract something of value from an economic standpoint. In fact, the U.S. was sort of suffering from an economic backlash because of that initiative to really try to put a man on the moon. Okay, as Kennedy would have said it. Okay, so there. I mean, the reason why you want to protect the technology could be political in nature as well. Another motivation would be social. The reason why you want to protect that technology is because it also protects your chances of survival. Okay, the survival of your village, the survival of your tribe, the survival of your community or society. Okay, and uh, and this is really part of our biology, so to speak, that need to preserve our species. No, and and because there's a need to survive, there's a need to protect our race, our tribe, our village, then there's a need for us to protect the technology that would enable us to increase our chances of survival. So the motivation becomes social in nature. Okay, you are socially motivated to protect technology. However, more often than not, perhaps 8 out of 10 or 9 out of 10, the reasons why you want to protect technology would be economic. Okay? And it's very practical. It's more commonsensical, and you want to be able to reap the fruits of your investment better by actually making sure that nobody takes advantage of that before you. definitely you're open to the idea that others will reap the benefits as well. But being the ones who've started it, you're more inclined to say, well, I want to be the one to take advantage of that first. So, and that's fine. That's perfectly fine. There's nothing wrong with that. I suppose at the outset, at the minimum. Okay. Of course, as you go in through the specific case, there could be some more circumstances which would probably change the evaluation of the scenario, right? If it is a technology that would help protect, let's say, a country, then maybe the economic motivation can be, not really removed, but could be put at a lower rung, at a lower level. Okay? But more often than not, I mean, if there's nothing really of higher value in terms of humanity, so to speak, that is required at that certain moment, then the economic motivation is usually the reason or the driver why technology is being protected. Now we go on to the object of protection. Now, when we talk about the object of anything, the object of protection, the object of technology management, we take a look at the one who is at the receiving end of the action. In this case, the one at the receiving end of the action, which is protection, is this what is protected. Okay, so the object of protection is really technology. Okay, now the thing here is that protection requires exclusivity. Uh, because tech protection implies that you can actually exclude access. Okay, that you can deny certain people from accessing or using what is protected or what is to be protected, in this case technology. Okay, so you cannot protect anything that is not excludable. You cannot protect anything that is not exclusive. Definitely, if your position is to be inclusive or bringing everyone together to use it, then protection is sort of a moot point, right? Because everyone would have access to it, so there's really nothing to protect. Okay, at least in the most obvious sense, right? Because you're getting everyone to access it, then how will you protect anybody who is not supposed to access it? It's a little bit of a confusing thing, right? I mean, it's probably an invalid thought. If you want it to be exclusive, then keep it exclusive. If you want people to have access to it and be inclusive, then I mean, protection as regards being exclusive is something that is not possible. Now, exclusivity is actually a physical attribute. Okay, the reason why you can exclude someone or you can exclude an organization or parties because there is a way for you to actually put a boundary in the space between what is protected and who that organization or that party or that person might be, right? So between the person and the technology, you can put a wedge in between them, and that's it. And generally, exclusivity is a physical attribute. Okay. For example, if I share an idea with you, okay, even if you don't like to hear what I'm about to say, okay, if I talk, okay, I share my idea, you will automatically get the idea. You will hear it. The only way for you to avoid hearing my idea is perhaps covering your ears, okay, or shifting your focus elsewhere, which is pretty much a physical method or a physical barrier uh, to avoid getting that idea. But right now, if you think about it, idea in its purest form is not physical, and therefore exclusivity is very difficult in that area. The only time that an idea sort of has some exclusivity is because that idea happened in a location wherein everybody else do not have access to that location. And that's what happened back in the older days, right? Wherein they don't have internet, their means of communication technology is still primitive. Okay, they probably don't have the newspaper yet, and maybe they rely on pigeons to exchange information. Well, the idea can still be exclusive, but the idea there is, if you know why, the reason why that idea was excluded from everybody else was because of the physical limitations of transferring or sharing that idea across. So therefore, exclusivity is actually a physical attribute. Nowadays, we're very much connected. You have the internet, you have social media, and everything. The only way that you can be excluded is if you don't have connection, okay, or if you're blocked, okay, so to speak. But in those cases, you can see that there is some physicality involved. There's some physical attribute there. So that's the idea of exclusivity. Now, in order for technology to be protected adequately, therefore technology must be embodied. Okay? There has to be an embodiment of that technology in order for you to protect that technology. Okay? The reason why you want to embody it is because by embodying the technology, you are taking advantage of the physicality of that technology. And therefore, being physical, now you can exclude it. Now you can establish a boundary between the technology and the potential person who would have access to that technology. Okay, so technology must be embodied. Okay, if you want to protect an idea, okay, as the saying goes, if you want to protect the idea, you're better off writing that idea down, okay, and establishing the fact that this is an idea that needs protection, as opposed to not saying your idea. You keep it to yourself, and sooner or later, somebody else would have thought of that idea. Okay, maybe he or she could have picked it up from you, maybe from somebody else, maybe through his or her own analysis would have come up with the same idea. I mean, there's nothing for you to protect anymore, right? You can't really lay claim to that fact that, hey, that's my idea. Okay, I want to protect that idea. Okay, therefore, you cannot use it. You can't do that, right? So that's why the idea of embodiment is very critical to the role of protection. Okay. Now, when we look at the scope of protection, okay, so the question is, what can be embodied? Okay. Now, there are actually three types, if you will, three cases or three categories of what can be embodied. The first is the product. I mean, it's obvious. Let's say you use your cell phone or your laptops or this microphone. These are products, right? And the fact that they're already physical, you can see them, they're tangible. Tangible meaning you can touch them, right? There's that sense of auto embodiment. It embodies themselves, right? So there's really no need for you to try to embody it. It's already there, therefore it can be protected. Okay, so the laptop, okay, your mobile phones, okay, even as simple as the table, okay, or the chair, as long as there's some physical attribute there, you can protect the embodiment. Okay, you can protect the technology. Okay. However, you're not just limited to the idea of the product. Okay, or in the case, let's say, of hardware, you're not only limited to hardware. So there are actually two more types that can be embodied, but the embodiment is not necessarily itself. Okay, so this would be process and use. In both cases, okay, the embodiment is actually a manifestation of the process or of the use. For example, if you take a look at software, software on its own is not physical. It's a bunch of code that is vicariously fed into a machine, which is a physical embodiment. Right? It's a hardware, okay, and through that machine, okay, the software will execute certain steps or certain tasks. Okay, so when you think of the embodiment, what is the embodiment? The embodiment would be the machine that runs the software. Okay, but the process is the software. So the challenge really here is that in the case of software, how do you protect software? Now there are schools of thought here, at least two. We can cite one. The first school of thought is that if you want to protect software, it has to be in an embodiment. So, which is why certain laws, in the Philippines is one of them, you cannot really patent, or but you can copyright, or you cannot really patent software because it lacks embodiment. You have to be able to define the embodiment of that software, and only then can it be protected. The thing there is that the loophole usually for embodiment is that if I choose a different body for the same process, then those are two different embodiments, and therefore those are two different entities, and therefore, protection is questionable if the protection only describe the first body and not the second body. So the nuance right now is that you want the embodiment to be as general as possible, so that whether it's body one or body two or body three, if all three bodies have the same minimum characteristics, then you can just simply say that, okay, the embodiment would be these minimum characteristics. Okay. But nevertheless, process is still embodied. Okay. What's another example for process? Maybe a way for you uh, to do a function in an organization. Okay. Yeah, there's a certain way for you to process things in an organization, certain function in an organization. Well, the function is your process. You can look at it in an abstract manner, right? Okay, so probably in your head you can imagine boxes and arrows flying around, but they're abstract. They're not really concrete. Okay, you can't really protect them. But what you can protect is the embodiment of that process, which is your organization or your team or your division. And that what can be protected. Now, if that process, supposing it's an R&D process, just for the sake of our example, if it's an R&D process, you want to protect your R&D process, well, you put it in a team and make sure that team is isolated, that not everyone would have access to that team, which is why in certain companies, it's not easy for you to just go into any team or any office. What you're protecting is the embodiment of that process. Okay. Another example would be the very first patent, so to speak, in the history of mankind is actually a recipe. So cooking, so it's a process. Okay, how you cook a certain dish. Okay, intellectually it's abstract. You know that, okay, you need ingredients. Okay, this is how you do. This is how you work on the ingredients, and therefore this is what happens. Okay, intellectually your recipe, and anybody can do that. Anybody can work on your recipe as long as they have all the basic givens at the start. Okay, but if it is not embodied, okay, if you don't actually go and cook the dish itself, okay, the dish, okay, what is really protected or what is protectable or what can be protected would be the dish itself towards the end, right? So that's another possibility for process, how you can protect process, right? So the embodiment is something that is manifested by the process, and that's what you can protect. Now, what about use? Use is not a very common type, okay, on what can be protected or what can be embodied. But similar to process, use has to be manifested, okay, in order for you to protect use. And typically, the cases that we see in use are generally chemicals. For example, if I have a chemical compound, XYZ, and I use that chemical compound for home cleaning purposes, well, that chemical compound on its own, okay, unless the chemical, even in that case, right, in the case of chemical compounds, there could be naturally occurring compounds and there could be synthetic or manufactured by human intervention, right? If it's naturally occurring, you cannot protect that. Yeah, that's already available. Okay, what you can protect is how you use that compound, which would probably involve some process. But generally, if it's a straight up use, you can still also protect how it's used, right? So the manifestation, okay, of how you use that chemical compound would be protected. Okay. Now, similarly, if I have compound XYZ, I use it for home cleaning generally, that's protected by somebody else. But I discovered that XYZ can also be used as a medicine. Okay. That's another way. Even if in both cases you're using XYZ, but you cannot really protect XYZ. Okay. You can protect the use. Okay. Uh, and typically, this is what we see in pharmaceutical companies. Really, the the protection is either on the process, on how they extract certain compounds, etc., etc., okay, or on the use of that compound for some specific application. In both cases, it has to be manifested. Okay. So now we see these three types, so to speak, of what can be embodied. In most cases, we see product embodiment. Second would be process, using software, using code, using technique or algorithms. Okay, can you protect algorithms? I think that's the one of the basic questions that you might be exploring in this area. Can you protect algorithms? Well, not. Well, the answer is no, unless it's embodied. Okay, in which case it has to be implemented, let's say, in a hardware. Okay, in something that's physical. So it has to be manifested. Okay. So so there. I mean, that's how we can understand the scope of protection. Now, when we look at the subject, okay, of protection, we ask who is the one who protects. And the very first subject of protection is the owner, okay, of the technology, or owner, quote unquote. Okay, what's the difference? Okay, sometimes we refer to the owner as the originator of the idea or as the originator of the technology. Okay. But more often than not, and this is what is accepted in legal understanding, is the owner, quote unquote, is actually the possessor of the title of ownership. Okay. And it's important that you have to have that title, okay, in order for you to draw the rights to that property or to that idea, to that technology. And just a quick reminder, and probably, and I hope you will cover this up in IT law if you have an opportunity to study IT law. Uh, Rights aren't really like the topmost important thing in any legal framework. What's higher than that is title, because the title is the one that grants the rights. Okay, and the rights will then tell you possibilities for privileges. Okay, so perhaps as you were growing up, you may have been told, okay, that sometimes we act as if we have the right to something, but really it's not a right; it's a privilege. Okay, and nowadays, actually, we hear this, especially with the younger people, that there is this sense of entitlement, right? And yeah, we normally comment people being entitled because probably uh, they feel that they have certain rights, but really the title is not to them. The title might be through the parents or through some family or relative, okay? But it's not their title. So in the case also of intellectual property, there is a title, okay? And that title is given to the person who is now the owner of that particular intellectual property. So in this case, when we talk about owner or owner in quotation marks, okay, um, there's this tension as to the recognition of who really owns the technology, who really owns the product. Um, Whether you view it as something fortunate or not, the owner, okay, okay, the one who owns the technology is actually the one who is the possessor of the title. Now, of course, it's possible that both the originator, okay, it's the owner is both the originator and the possessor of the title. That happens. Okay. However, once you start going into the ideas of intellectual property management, you will notice that's not always the case. Sometimes people will have to sell their technology, and once they do that, they're no longer the owners. They're no longer the possessors of the title. Maybe history will remember them as the one who thought of the idea, who developed it, who popularized it, but the ones who will extract value, economic value from that technology is no longer the originator because he or she would have sold that technology to the eventual possessor of the title. And you will see this. I mean, you will see in the history of technology uh, that maybe in our textbooks we will know so and so to be the one who invented the technology, but in the end, they're not the ones who will benefit from that technology. And what most people do not understand is we may hear of stories wherein the inventors invented something and then they die poor, but their invention was really like a blockbuster hit. So the question is, why are they poor if they're the ones who developed this blockbuster thing? Well, that's the nuance, unfortunately, of intellectual property. Okay, maybe at that time the inventor sold it very cheaply to the eventual possessor of the title, and that's it. The possessor of the title was fortunate enough to develop it even further and was able to move it to commercialization. So now you can see the connection between intellectual property, okay, protection, and in relation to exploitation, okay, technology exploitation. And perhaps in the negative connotation, we can see that a lot of the inventors can be exploited, right? Some of the brilliant inventors, they may not have the capital to back them up, okay, and because of certain need, okay, they have no choice but to actually sell their idea, sell their technology. And unfortunately, they've already reaped the benefits of that technology by selling it. So if you're not really careful on how you value your technology, your idea, you might undersell it. Okay? And it happens. You might think of it as a sad thing, right? Uh, I don't want to sound dismissive or I don't want to sound harsh, but that's the world we live in, right? And I'm hoping that our inventors, especially our inventors in the Philippines, would be supported by those who know how to manage intellectual property very well. Okay. But for now, I mean, for the purposes of academic appreciation, you have to understand that the originator of the technology is not necessarily the possessor of the title for that technology. Now, who else protects? Well, some higher authority. In this case, it will always follow the legal framework and paradigm of the locality. So the intellectual property laws vary from one country to another. Okay. And one way to try to harmonize the legal frameworks across countries is that they have treaties. Okay. So through treaties, now it's possible for one country to seek protection uh, from infringement that would have been done in other countries. Okay. Now, unfortunately, not everyone would be subject to the same treaty. So um, I forget which countries are involved there. But I mean, you can tell that different countries would follow different treaties. Okay, I know Europe, the entire of EU, would have a common treaty concerning intellectual property. So what is protected, let's say in Austria, is for sure protected in Spain, because now they're bound by not by the laws of their individual countries, but because of a treaty that transcends national boundaries. Okay? But more than that, protection can be done as long as there is a higher external authority. Okay, and how is that different from the owner? Well, as the owner, if you are surely the possessor of the title and you're the originator of the idea, you can protect it in your own way. Okay? Perhaps the most crude way of protecting it is, denying certain people access to your technology, and that's usually what happens at the start. Okay, but eventually, the owners will have to elevate it to the higher authority so that the higher authority would be able to protect the technology better. Okay. So, in a sense, the owner is now not really obligated, but the owners are now convinced or or influenced to make sure that they disclose, okay, the technology, the idea behind it, so that they can be granted the title by this higher authority as the true owners of the technology. Now, unfortunately, we know that things can be a little bit devious or shrewd. I mean, if there's that potential for leakage, right? I mean, you hear of someone doing a great idea and you've had access to that, you're able to get a leak uh, from that portion, and then you were the ones who announced to the world that I'm the originator of the idea. Unfortunately, for the real owners, in the eyes of the higher authority, you are now the possessor of the title. That happens, and of course, now the thing there is that you go into court battles, right? The true owners will then say, you're not the real owner. No, you stole it from us. You took advantage of a leakage. Okay, uh, that's out of scope for our subject today. But what's important here is that who protects? It's both the owner and the higher authority. Okay? Is it possible for some other collective or entity to protect? Okay, technology or the idea. Okay, uh, perhaps you can look at the level of associations, business associations or industry associations. They could exert some effort, but their scope is not very powerful compared to a higher authority like government or like a global agency that really enforces all of the treaties. Okay. Um but the associations, they can exert moral suasion so that those who may be using the technology indiscriminately or illegally may be persuaded to pay the true owners some sort of royalty, perhaps. So this is where the idea of licensing comes into the picture. Um, that the one who has the title can actually let other people use that technology, but in exchange for something. Right? So that's the concept of licensing in that case. So in conclusion, wrapping up the commentaries on how to protect technology or protecting about technology, well, it's really about intellectual property management, right? And the first insight that I'd like to share here, it's not just the legalities. Okay, the first step, the most obvious thing that we explore when it comes to intellectual property is that it's a legal thing, right? There are laws. I need to memorize the law, let's say, in the country in question in order for me to know the intellectual property dynamics of that country. Okay, I mean that's the usual first step. But as you know, I mean the motivations are not simply economic in nature. There are a lot of legalities that are in sway, um, and depending on the prevailing motivation, that's where your intellectual property management would have to decide on the right course of action, right? In fact, it is even possible for you to protect something, and this is counterintuitive, right? You can protect something by letting people use it to a certain degree, right? And that's usually the tactic in some applications, some platforms. Okay, I'll let you use the technology, but I don't let you use everything. So it's like I'm giving you like a teaser or a taste of the technology, but it's not the whole thing. So now you can imagine that when it comes to protecting technology, it need not be an all or nothing thing, right? It's either you use everything or you don't use it. No, you can actually chop it down. And that's the reason why it's important that they have to be embodied, because now Because they are embodied, it's easier for you to see if you can compartmentalize the embodiment. Then you can have smaller parts, smaller bodies, right? And you can now decide which smaller bodies to protect and what smaller bodies to be open for access in general. Okay? So it's not really about the legalities. It's also about strategy. It's also really trying to understand, well, what are my motivations? And depending my motivations, and that's the time I decide on what technique I could use, which would include probably excluding people from using technology. Okay, that's one way. Now, the second insight here is that protection needs to be physical. At the very least, it has to be documented. The documentation being the title of ownership. At the very least, you need to be able to say or establish that because I'm the originator of the idea, therefore I am the first possessor of the title. Eventually, possibly in the future, I can sell that title to somebody else, okay, and extract some benefit out of it, okay. But it has to be documented. It has to be established. Okay? So the physicality required for protection has to be complied with. I mean, you cannot say that I'm going to hide my technology, it's just going to be in my head. I can protect it because it's in my head. I remember if we go back to the very premise of technology by itself is useless, right? So if it's just going to be some idea, then it's not going to be useful anyway. So it has to be embodied. Okay, it will have to be embodied. Okay? It has to be embodied. Has to be embodied. Okay, so that's the idea, the second insight that we can draw from this commentary. And the third is really securing the proper entitlements. Okay, and that's where your uh, dealings with the higher authority will count a lot. Okay. Right now, at least in the Philippines, I know, at least for the past 10 years, 15 years, there has been a very aggressive campaign to really tell inventors, artists, so on and so forth, that their intellectual property need to be protected. Okay? And sometimes inventors, especially the ones who cannot really afford at the start, well, they don't know that there are certain things like this. So we hear of sad stories that okay, this guy was so smart, but was poor. Okay, came up with a brilliant idea, and then that brilliant idea was stolen by an evil, nefarious capitalist. We probably see that on shows on TV or movies, right? Well, I mean, it's not far from the truth. It's not far from reality. And one thing that we have to be aware of is that we try to secure the proper entitlements. I suppose you're that poor inventor, so to speak, just for the sake of argument. If you're that poor inventor, how would you know that you actually need protection, right? That you need to engage with the higher authorities, right? If nobody's really approaching you and all that. Um, well, the one way for this poor inventor, perhaps, to start is uh, maybe he or she needs to resolve himself or herself as to what value can be extracted from the invention, right? And sometimes inventors, because they're poor, perhaps they're motivated by higher values, right? So probably they're not in it for the money. But if you think about it, it's such a shame, no? If they may not be in it for the money, but if they can extract money from it, that would even lead them to come up with more ideas, more brilliant ideas, then it's a shame. It's a waste, right? But nevertheless, some of them might be motivated by higher values. They need to talk to themselves or address to themselves, what value do I intend to extract from this invention? Okay? If it's monetary, then he or she will have to ask people around how to make sure that that value is protected, that there is actually that return of investment, a return of capital to it. So, but then again, not everyone is perfect in the sense that no matter how much information that is given to you from outside, no matter how much common sense can be exerted in these particular situations, we can always suffer from what is known as a trembling hand, right? Just because we were affected by certain emotions, we can come up with a suboptimal decision. It can happen. Okay. So, but nevertheless, assuming normality, assuming ideal conditions, right? We have to do our best to secure the proper entitlements for for the technology that was developed. Okay, and with that, I end my short lecture on protecting about technology. Are there any questions about the topic?